Aboriginal and Torres Strait Islander peoples should be advised that this video contains images, voices and names of deceased persons. Ninyari, Nalawanyan, Maribajari, Gadinyirida. Today we stand inside the Federal Court of Australia, a building that symbolises the legal system's promise that disputes may be heard, evidence tested and rights upheld. But in Cubillo and Commonwealth of Australia, this promise was exposed as unstable and incomplete. This case offers, to a significant extent, a lens through which the Anglo-Australian legal system appears as a structure that proclaims equality in principle, while in practice prioritising the appearance of justice over its meaningful application. The proceedings were brought by Lorna Cubillo and Peter Gunner, Aboriginal plaintiffs who alleged that as children in the Northern Territory they had been forcibly removed from their families. Their claims formed part of the broader and deeply contested legal history of the stolen generations. The 1999 decision was not a final determination of liability, but an interlocutory application in which the Commonwealth sought summary dismissal of the proceedings on the basis that the applications had no valid causes of action, that their claims were statute barred by limitations law, and that the actions were barred by the equitable doctrine of laches. Subject to observations about deficiencies in the applicant's pleadings, Justice O'Loughlin rejected the Commonwealth's application and the matter proceeded to trial. While this may appear to reflect procedural access and judicial openness, the continued course of the litigation reveals a significant contradiction. At trial in 2000, the plaintiff's claims were dismissed, and the full federal court dismissed the appeal in 2001. What we must examine is the distinction between access to the law and meaningful legal redress. The legal system may permit a claim to be heard, yet still prove unable or unwilling to translate that hearing into remedy.
The applicants of this case were Lorna Cubillo and Peter Gunner. Lorna Cubillo was taken from Phillip Creek Settlement in 1947 when she was just 8 years old. She was taken with other children to the Retta Dixon home in Darwin, where she received corporal punishment and on at least one occasion was viciously assaulted by a missionary worker. She remained there until 1956. Justice O'Loughlin himself acknowledged that her removal would have been a sad and traumatic event, one that would leave a lasting impression on a young mind, accepting that she suffered in silence and continues to suffer. Yet this did not translate into legal remedy. Similarly, Peter Gunner was removed from Utopia Station in 1956 when he was just 7 years old and taken to St Mary's Hostel near Alice Springs, where he remained until 1963. Whilst evidence of his mother's consent was given in the form of a thumbprint on a consent form, there was no way of knowing whether she understood the contents of that document, revealing the profound inadequacy of consent obtained from First Nations people within an Anglo-Australian legal system that disregarded Indigenous literacy, language barriers, and cultural differences. This reflects the presumption of regularity, which assumes that all official documents are genuine unless contrary evidence is presented. The applicants claimed that their removal and detention were unlawful, arguing that the Commonwealth was responsible because the Northern Territory was under Commonwealth administration at the relevant time, as highlighted by Cunin and Gritz, where fiduciary duty argument was said to arise from the Commonwealth's vast power and control. Under the Aboriginals Ordinance 1918, the Chief Protector was granted exclusive authority over Indigenous people in the Northern Territory, including total control over Aboriginal women and the power to assume guardianship of Aboriginal children, powers that were exercised, the applicants argued, unlawfully and without proper regard to their individual circumstances. The causes of action they brought included wrongful imprisonment, breach of statutory duty, negligence, and breach of fiduciary duty. As academics such as Larissa Berendt have noted, the decision to bring civil claims rather than seeking political recognition placed the burden of legal proof on the plaintiffs. Thus, lived experiences of removal and separation had to be translated into requirements of private law doctrines, a legal doctrine that historically rendered Indigenous suffering as legally invisible. The 1999 judgment raised questions on whether relevant circumstances were properly considered before the children were taken, and if these causes of action support civil recovery at all.
When the case came before Justice O'Loughlin, the parties presented two opposing views of the law. On one side, the Commonwealth, represented by Senior Queen's Counsel, argued that the case should not proceed to trial. On the other, Lorna Cubillo and Peter Gunner, represented by the Northern Australian Aboriginal Legal Aid Service, argued that they had been wronged, that the law recognised that wrong, and that they deserved to be heard. The court had to determine whether they should be allowed to proceed. The Commonwealth argued that the proceedings should be dismissed before trial and advanced 4 grounds for doing so. First, the plaintiffs' claims disclosed no legally sustainable cause of action. Second, even if a valid cause of action existed, the claims were statute barred. Third, the plaintiffs had no basis for obtaining an extension of time. And fourth, even if such a basis existed, the circumstances were so extreme that the court should refuse to exercise its discretion in their favour. However, underlying all four arguments was the issue of time. More than 40 years had passed since the events in question. Key witnesses had died, including the patrol officers alleged to have removed Mrs. Cubillo, the superintendent of the Retta Dixon home, station owners, former directors of Native Affairs, and senior political figures such as Sir Paul Hasluck. The only surviving director was too ill to give evidence. The Commonwealth argued that this delay had caused irreparable prejudice. It could no longer test the plaintiffs' accounts against the evidence of those directly involved, or adequately explain how policies were developed and implemented. As a result, it argued this would not be a fair trial. Beneath this sat a broader legal claim. The Commonwealth contended that courts had no jurisdiction to review the desirability of policies authorised by Parliament. The removal regime existed because legislation permitted it. Governments, it argued, cannot be held liable merely for implementing powers Parliament has lawfully conferred. The Commonwealth therefore challenged each cause of action individually. On wrongful imprisonment, the directors of Native Affairs possessed statutory power to take Aboriginal peoples into custody, meaning there could be no false imprisonment. The legislation created did not contain any provision for civil recovery, so no private right to sue for breach of statutory duty. The welfare legislation did not give rise to a common law duty of care, and decisions made under those statutory powers were protected from negligence liability, nor did the directors' statutory powers create a fiduciary relationship. Finally, the Commonwealth relied on limitation periods. Mrs. Cubillo's false imprisonment claim, it argued, should have been commenced by 1962, yet proceedings were not filed until 1996. Mr. Gunner faced the same difficulty. The Commonwealth said the law requires finality, and the delay was simply too great to overcome. Lorna Cubillo and Peter Gunner did not deny the difficulties created by the passage of time, but said that because they had sustainable causes of action, they had a right to be heard, and the question of delay and prejudice could not be decided until the court had heard the evidence. At this stage, they were asking for something fundamental to the Anglo-Australian legal system, the opportunity to have their claims properly tried. The power to summarily dismiss proceedings is one that must be exercised with exceptional caution, and only where it is clear that there is no real question to be tried. The plaintiffs argued that real questions existed here, requiring a trial. On wrongful imprisonment, they accepted that the directors possessed statutory powers over Aboriginal peoples. What they challenged was how that power was exercised. Their case was that the directors exercised those powers not in the interests of individual children, as the legislation required, but pursuant to a broad, indiscriminate policy of removing Aboriginal children without any regard to their individual circumstances. If a statutory power is exercised for an improper purpose, it is exercised unlawfully. Whether that occurred could only be determined through evidence in a trial. On breach of statutory duty, the plaintiffs pointed to the legislation itself. The director was under a duty to provide for the custody, maintenance, and education of Aboriginal children. These were legal duties, not merely aspirational statements. Because the legislation was designed to protect a specific class of people and provided no alternative mechanism for enforcement, the plaintiffs argued that a private right of action could be implied. The plaintiffs argued that the relationship between the Commonwealth and each applicant gave rise to a duty of care. The director held extraordinary control over their lives and was required to act in their interests. If that power was used for other purposes, he was outside his statutory authority, and if foreseeable harm resulted, liability could arise. Whether such harm was foreseeable in the 1940s and 50s was a factual question, again requiring evidence. On fiduciary duty, the plaintiffs relied on the fact that the director was their statutory guardian. Anglo-Australian law recognises the guardian-ward relationship as fiduciary in nature, recognised by the High Court in Bennett and Minister of Community Welfare. The Commonwealth held overwhelming power over the plaintiffs, who were entirely vulnerable to its exercise. If that power was used to advance assimilationist objectives rather than the children's interest, a breach of fiduciary duty was at least arguable. The plaintiffs also rejected the suggestion that responsibility rested solely with individual officials. The directors were Commonwealth officers operating within a chain of command that ultimately led to the Commonwealth government. What was done, they argued, was the implementation of Commonwealth policy. On limitation periods, Mrs. Cubillo first became aware she had a potential legal claim when told by her solicitors in September 1996. Mr. Gunner was first informed by his counsel in July 1996. They argued that they could not reasonably have brought their claims earlier because they did not understand the legal significance of what had happened to them until the mid-1990s. The connection between their childhood removal and their later injuries only became apparent through legal advice, medical diagnosis, and the broader national conversation generated by the Bringing Them Home inquiry. The legal answer relied on Section 44 of the Northern Territory's 1981 Limitation Act, which gave the court broad discretion to extend time where facts material to the plaintiff's case were not ascertained until after the limitation period had expired, and the action was commenced within 12 months of those facts becoming known. The question of whether that discretion should be exercised, the plaintiffs said, could not be determined without hearing their evidence. It had to be dealt with at trial. not before it. And so the question before Justice O'Loughlin was, is this case so clearly bound to fail that they should be dismissed without a hearing? The plaintiff's arguments exposed a deeper tension within the Anglo-Australian legal system, a system that proclaims equal access to justice in principle, yet was being asked whether procedural barriers should prevent serious allegations from ever being fully examined. The question was whether the promise of justice would be given meaningful effect, or remain merely formal.
Justice O'Loughlin found the plaintiff's claims in negligence, false imprisonment, breach of statutory duty, and breach of fiduciary duty all raised serious contested questions of fact and law requiring a full hearing. The issue before the court was not whether the plaintiffs would probably succeed, only whether their claims were capable of proceeding at all. The obiter was more revealing. Justice O'Loughlin remarked on the degraded evidentiary record and the death of material witnesses, observations unnecessary to the decision, prophetic of what laid ahead. As Barrett notes, he acknowledged the guardian-ward relationship as capable of giving rise to such an obligation, but left the matter open for want of evidence at this stage. But what the interlocutory decision gave, the trial took away. After 107 days of hearing, Justice O'Loughlin handed down judgment on the 11th of August 2000, dismissing every cause of action. At trial, he did find that a duty of care arose from the statutory obligation under Section 5 of the Aboriginals Ordinance 1918 and Section 8 of the Welfare Ordinance 1953 to supervise and regulate the institutions. But in Cubillo's case, conditions at the Retta Dixon home were found insufficiently poor to constitute a breach. The fiduciary duty claim failed entirely, Justice O'Loughlin holding that even if a fiduciary relationship existed, no breach had been established. The false imprisonment claim failed because Gunner's mother was found to have consented to his removal, evidenced by a thumbprint on a form, despite her illiteracy. As Clark observes, the judgment treated the protection laws as benign in their intent, a characterization that shaped every finding that followed. As Liebersman concludes, the common law was ultimately complicit in reauthorizing the wrongs committed, with the Commonwealth expending extensive funds and time defending their actions, even claiming that removals were beneficial.
While superficially, the 1999 case meant a recognition before the law, when looking at the case critically, this doesn't hold. After the 1999 case, the plaintiffs still had to move through doctrines that were not designed for historical removal. They had to prove old facts through surviving evidence. They had to show causation through decades. They had to fit their experiences into individualized legal claims. This is where Cubillo becomes more than a procedural case. It shows that law can open its doors while still controlling the terms on which a person is heard. But even looking at the case itself, we see that equality before the law is superficial. The analysis we will give reveals the strong extent to which Cubillo can be used as a lens through which to view the Anglo-Australian legal system, because it reveals how the law can offer only a superficial form of justice, recognition, procedure, and access to courts, without a full understanding of the historical and cultural harms being claimed. In this sense, Cubillo shows that being heard before the law does not necessarily mean being understood by it.
Legal form was the killer of nuance. The indescribable suffering of the Aboriginal children couldn't translate perfectly into the hard categories that the Western legal system desired, so they were forced to change. In Cubillo, removal from family became wrongful imprisonment. Institutionalization became negligence or a breach of statutory duty. The relationship between Aboriginal children and the state became a possible fiduciary obligation. Decades of silence became a delay, lost records became prejudiced, memories became evidence. This is not necessarily a failure of the individual judicial reasoning, it is how the Anglo-Australian law works. It breaks social complex and historical harms into elements, tests, burdens, and categories, but it can also reduce the scope of what the law is able to see. Davies helps explain that this is not just a problem of one case, but a feature of the Western legal method itself. Law claims neutrality while filtering harm through its own categories of recognition. Furthermore, as the authors of Once Upon a Time in Australia note, the focus on categorization often destroys nuance around conversations such as truth, where legal truth is seen as the truth, and everything not acknowledged by a court of law is seen as fiction. In a similar vein, the categorization of the harms reduced the seriousness of what occurred. The harms were only as serious as the categories they could fit into. If they lost the case, then they were seen as liars, their struggles seen as insufficiently proven to matter. If they could ever win the case, they would likely simply be paid money to compensate for the damages, given money to try and seal a wound that no amount of dollars could fix. As Mayerson notes, the problem with formal equality is that it does not change the entrenched injustice.
I would argue that legal reasoning can appear fair because it insists on equal treatment, while still failing to adequately respond to systematic disadvantage faced by Aboriginal and Torres Strait Islander people. Because equality in process is not the same thing as equality in outcome. Mayerson draws on the example of an employer who makes it a condition of employment that an employee must not be the primary caregiver of a small child. This amounts to indirect discrimination against women, since more women than men are primary caregivers of small children. Following the Racial Discrimination Act of 1975, which is a piece of Commonwealth legislation, and the 1967 referendum, outright discrimination has become forbidden, but the indirect discrimination that Mason warns about still remains. This is outright stated in our analysis about legal form and the lack of translatability, and will also be apparent in our analysis on time and evidence. But the thing is, the courts don't ever promise justice. In the case of Telstra and Trelaw, the courts cite a reason for stare decisis as the appearance of justice, but not justice itself, and the reason for why becomes apparent in the 1999 case of Cubillo. But this is not something we ought accept. Even if the system is perfect for the majority and imperfect for the minority, this is not a system that is just. As Ursula Le Guin notes in her short story, The Ones Who Walk Away from Omelas, if a society is good but relies on the suffering of even one, then that is not a society that is moral.
The limitation question cast a long shadow over the entire proceeding. Under the Limitations Act, Northern Territories, actions in tort must generally be brought within 6 years. The removal had occurred in 1947 and 1956. The proceedings were commenced decades out of time. The plaintiffs sought extensions, relying on provisions deferring the running of time where a plaintiff was under a disability, and argued that the Commonwealth's own conduct had contributed to the evidentiary difficulties now being deployed against them. The Commonwealth drew on Walton and Gardiner, 1993, and Rogers and the Queen, 1994. Where Justice McHugh identified abuse of process as including proceedings that are unjustifiably oppressive to a party, to argue that delay of this magnitude made a fair trial impossible. As Clark concludes, the case turned, perhaps more than anything, on the overwhelming prejudice to the Commonwealth of claims being brought more than 30 years out of time, when relevant records had disappeared and witnesses had passed, such that successful litigants would ultimately be selected on criteria unrelated to the underlying justice of the situation. A further obstacle compounded this. As confirmed on appeal, Australian law does not permit the superimposition of fiduciary duties on common law duties, merely to improve the character of available remedies. The plaintiffs could not use equity to supplement what tort had already failed to deliver. These rules are formally neutral, but as the Quemolinas argue, locating events of continuing legal significance in the far-off past allows the damage caused by these events to be viewed as ameliorated, or at least shown of some of their legal consequences by the passage of time. And one of the hurdles facing stolen generation claimants are limitation statutes, which operate to bar legal claims after a certain period of time has passed. The limitation doctrine embeds a linear Western concept of time into law structure, one entirely foreign to the plaintiff's own legal reality.
The later decisions complete the picture. After surviving the 1999 application, the plaintiffs proceeded to trial. In 2000, Justin O'Loughlin dismissed the claims, and in 2001, the full federal court dismissed the appeal. The 1999 decisions demonstrate procedural openness, and the later decisions show the difficulty of substantive remedy. The evidentiary burden proved to be insurmountable. As Cunin and Griggs highlighted, the deaths of key witnesses and the loss of administrative records meant that establishing the specific facts required by each cause of action was extraordinarily difficult, as most of these decisions were made by government officers who, by the time of the trial, were largely dead or unreachable, hence placing Cubillo and Gunner in a structurally impossible position. The National Inquiry in the Bringing Them Home Report 1997 found that removal decisions across the Northern Territory were often made without written authorisation and without records of the circumstances considered. Where it existed, such as Gunner's case, Justin O'Loughlin concluded that the evidence did not justify a finding that the Director of Native Affairs removed Mr. Gunner from his family against the wishes of his mother. This illustrates how the presumption of regularity operated in practice, filling evidentiary gaps in favour of the Commonwealth. Together, this highlights a legal system capable of hearing historical claims but only through demanding requirements of proof, causation, liability, and doctrinal recognition.
In 1999, Lorna Cubillo and Peter Gunner were not turned away immediately. Their claims were allowed to proceed. But the litigation as a whole shows that being allowed into court does not guarantee that law can fully recognise the harm before it. Cubillo exposes a legal system that is committed to fairness, but fairness expressed through procedure. It is committed to proof, but proof often depends on the archives created by the state. It is committed to equality, but equality is often formal rather than substantive. That is why the case remains significant. It shows both the promise and the restraint of Anglo-Australian law.